Hello and welcome. Today we are going to be talking about how your business can survive a lawsuit. It isn't that complicated, but it's important to know that these steps or these things that you can do to help you so that sorry. It's not a matter of if, it's a matter of when you get sued. Most businesses do. It's just it should be a standard cost of doing business. And we're going to talk about the steps that you can do to make sure that you survive and that you're not putting your entire business at risk for people that may not have. If you're new here, my name is Taylor Darcy from Think Legal, where I help you create the business of your dreams. And part of that is addressing the legal needs and possible concerns of your business. So let's get started. Number one, if you receive any type of documentation, a demand letter, summons and complaint, make sure that when you receive those, don't panic. These are standard things that happen all the time. It should not be a surprise, first and foremost. If it is a surprise, that's another issue entirely. But if you receive these things, be aware that it typically is because of somebody who is unhappy and didn't get what they were looking for. So you have to decide what that's worth to you to fix. So that's number one. Don't panic. It only makes it worse when you don't panic. When you panic, it only makes people that panic. They put off going to an attorney. They put off going to see somebody that can help them with their legal needs. And it ends up that it costs them more money by panicking and putting it off. Procrastinating will not make it go away. Putting it on the back burner and hoping it goes away will not make it go away. And so you really want to make sure that you address it as quickly as possible. And you can do that in a couple of ways. Number one, you want to review any relevant contracts that you have with the opposing party. If you don't have a contract, review any contracts or any type of communications you have with the other party, which brings me to a very valid point. If you don't have a contract, please make sure that you do get a contract for these parties, especially if it's a contract issue, if it could be a contract issue. And you want to make sure that your contracts are customized and to specific parties. Make sure that you're doing what you need to do to protect yourself. Next thing you want to do is make sure that you're reviewing the demand letter with an attorney or the summons and complaint, whichever one you've received. Those are the main three documents that you'll receive at some point that will indicate whether or not you're being sued or potentially could be sued. And the reason why this is so very important is if you can settle it before it gets to litigation or before the answer is due, that's always the optimal scenario because it's the least expensive stage of a lawsuit. It's this point at which spending money on settling is a better deal than spending money on the attorneys. If you wait and you don't file an answer, then you could be at risk for what's called a default judgment, which is just a simple way of saying you don't disagree with it, so the courts are going to rule in the other party's favor. Next thing you want to do is you need to evaluate your litigation budget and what that is. And here's my point. Everybody, if you consider that if you're more likely to be sued than not, you need to be saving for your lawsuit, which means putting a percentage of your profits in a separate bank account, in a separate savings that you're budgeting to be sued at some point. That way, legal costs are not surprise. You're prepared for this rather than doing like a lot of business owners do where they just hope and pray it never happens to them. The smart thing to do is have a budget set aside for legal costs, not only to draft contracts, to form entities, but also to defend yourself in the case of litigation or to prosecute litigation. That's the other side of it. Is if someone, it goes both ways. It isn't always about defense. But being a smart business owner, you're going to budget for that extra expense. You're going to be so much happier that you did because it's not going to be, oh no, I have to spend this extra money that I don't have, that I don't want on something I don't want or don't need. And it also means that you can spend the money on prosecuting, being the plaintiff is the other way of saying it, if there's a breach of contract or if you need to sue somebody, and that it's not a surprise, that you're not hoping and praying that it doesn't happen. Because unfortunately, the truth is that if you're more likely than not going to sue someone or you're going to be sued. Those are the truths. Those are the absolute truths. The next thing that you're going to want to do is, and I tell this to all my clients or my previous litigation clients, is how much is your pride worth to you? Because if you stand on your pride so much that it ends up costing you thousands of dollars in legal fees when you could have just settled for that same amount or lower, then it makes a ton of sense to just settle. So don't let your pride cost you money. In any settlement agreement, nobody agrees that they were at fault. It's just the exchange of money at that point. And so you don't let that be the determining factor on whether you settle or not, because you can not admit fault and settle at the same time. And that just is a safe, every attorney is going to do that. It isn't dependent upon who you hire for that. So just keep that in mind. Check your pride, because if you can settle something, if the complaint or damages was for $5,000 and the other party it's going to cost you $5,000 to $10,000 in a retainer for the attorney, then it makes more sense to spend the money on settling than it does to hire that attorney, because then you can have it be done with instead of incurring the additional costs that go with an attorney. The next thing that you're going to want to do is, if you can't settle it or you don't want to settle it and it's too expensive to settle it, check your insurance policies to see if you can, what's called tendering your defense to your insurance company. This means that they take over and will spend the money if necessary to settle it. Think of a car accident. When you tender your defense to an auto insurance company, they then go through and make sure that all the T's are crossed, I's are dotted, and they'll pay out if necessary. A lot of times they'll settle, sometimes they won't. And for insurance companies, it really comes down to what the best bang for the buck is. In other words, if they believe that it'll cost them, and I'm just using a number here, $20,000 to defend the lawsuit, and the damages are $50,000 or $100,000, then what they're going to do is they're going to defend the lawsuit, because it's cheaper at that point for them to defend the lawsuit than it is to pay out the lawsuit. They are strictly a numbers game. They do not care about right or wrong. It's simply about money for them. In fact, the lower the money that they have to pay out, the better. They can be difficult because they will not necessarily settle even if it's in your best interest to have it settled, because it's just dollars for them. The other part of that is that if they deny the claim, then it can cost you, then you're liable for it as well, as opposed to if they and also if the claim exceeds the policy limits. So say someone slips and falls and it costs $500,000 or that's what the plaintiff is asking for, then your insurance company is only for $100,000. Well, even if they settle for the maximum amount at that $100,000, you could still be on the hook for that remaining balance of $400,000. So it's very important that you're reviewing your insurance to make sure that it's covering most of your things, and that you're not gonna avoid liability, or they're gonna avoid liability, and then it be costing you that. If for some reason you don't have insurance, or they don't accept the defense, or it exceeds the policy limits, make sure you hire an attorney to defend you if necessary. The last thing you want to do is just accept the premise of the other party that you were wrong in its entirety. Oftentimes, frequently, and I mean more often than not, they will put in the demand letter or the summons and complaint the most expensive way out of the problem as possible, because they want to get the maximum amount. And you also start from a higher point, and typically you you fall back to your lowest point. And so the reason why that's important to know is that hiring an attorney to defend you is absolutely crucial to making sure that you're getting the best deal possible. Their premise is based upon idealistic numbers. You often, even after you've gone through the problem of answering the summons and complaint, you frequently can settle a court case for a lot less money than what it would have cost otherwise. Now, is it going to be the same as if you'd have settled it before the summons and complaint and before the demand? Probably not, right? It's always more expensive to settle later than it is to settle sooner. I shouldn't say always, frequently, very frequently. So next comes, and this is like the proactive approach. Right now we're talking about just strictly defense, but the next steps are your proactive approach. Look at your contracts. Have an attorney review your contracts to make sure there are no gaps, because oftentimes where the lawsuit wins is when there's a gap in the contract relative to that person's claim. So you really want to make sure that you're protected, that you're not just doing this willy-nilly and just, based on your gut, or make sure that things get put in writing. And if there's an issue with that contract, make sure that it doesn't hurt you going forward, right? You can't fix the past. Like, you can't go back in time and sign a contract that's, it doesn't work. Nobody's going to sign away their rights. But going forward, you can have them execute a contract that is more favorable to you. So keep that in mind as far as your contracts are concerned. Next, last and certainly not least, is if you are a sole proprietor, if you're not an entity yet. Entities such as an LLC or a corporation or a LLP, limited liability partnership, cannot help you in the current case. However, if you're a sole proprietor with just doing as a DBA, no LLC, then getting an LLC now in order to move forward with it will make it so that futuristically it will protect you and your business going forward. So if for some reason you're not a company, a limited liability company, corporation, now is as good a time as any to get that done so that you can start rewriting contracts and start having it so that you're this liability shield that goes with it. Because if you're a sole proprietor, you have unlimited liability. And that's not a great place to be in because they can attach assets like your house and other various things. So you really want to sit down and evaluate. If you're subject to litigation, make sure that you move in this direction towards making a full-fledged entity. In California, there's an $800 minimum tax. It can be a great way. It's a small price to pay relative to the amount of cost of a litigation. And so having that LLC or that corporation will give you the benefits that you don't have as a sole proprietor. And we've talked about these in other videos, so please refer to those videos. This one, we're not going to go into too much depth of as far as what that LLC is, but these are all ways that your business can survive a lawsuit. You want to make sure you're proactive. Proactive is always cheaper than passive when it comes to especially guarding against lawsuits, by having insurance, by having good contracts, and by having a business entity. Now, will that eliminate everything? No, that won't. I'm not suggesting that it will, but just like for those of you who are old enough to remember Club, it was more of a deterrent because it was a visual deterrent. People could see it, and so they would keep on walking to somebody that didn't have a club, than it was a deterrent for somebody that was very determined to get it, because there are ways to thwart that. The same thing goes for car alarms. That's what these are. These are tools that can be used. The LLC, the contracts, insurance, these are tools that can be used that will deter people from suing you frivolously or without merit. That will give you the best opportunity for success. That's how you survive a lawsuit, is by making sure that only lawsuits that have merit get brought, if at all, if necessary. But by doing these steps, you can really protect yourself and give yourself the best opportunities for success. Ends today's. If you have any questions, comments, concerns, leave them in the chat below. I'm here to help you. Talk to you later.